Good morning and welcome to the 40th meeting of the Criminal Justice Committee in 2024. We have no apologies this morning, and our first item of business today is an oral evidence taking session on an affirmative and a negative instrument. So, namely, the Electronic Monitoring Use of Devices and Information Scotland Regulations of 2025 and the Electronic Monitoring Approved Devices Scotland Amendment Regulations of 2024, and that's SSI number 354 of 2024. So we're joined this morning by the Cabinet Secretary for Justice and Home Affairs, and I also welcome to the meeting Mr Graham Robertson, Head of Public Protection Unit, David Gallagher from the Public Protection Unit, and Jamie McQueen of the Legal Directorate of the Scottish Government. And I refer members to papers 1 and 2, and I intend to allow around about 20 minutes for this evidence session. So can I start off with inviting the Cabinet Secretary to make some opening remarks on both the SSIs. The Cabinet Secretary.
Thank you, Convener, and good morning to colleagues. The regulations before you all today, if approved, will enable the use of GPS monitoring devices for the first time in Scotland for the monitoring of people as part of the criminal justice system. We have laid under negative procedure the Electronic Monitoring Approved Devices Scotland Amendment Regulations 2024. Those amend the previously laid 2020 regulations to approve GPS-enabled devices as the types of electronic devices which are designated as approved devices for the purpose of electronic monitoring. The affirmative instrument before you today, the Electronic Monitoring Use of Devices and Information Scotland Regulations 2025, governs the use of those devices. These regulations will work together to prescribe the terms of use of GPS devices to monitoring compliance with certain conditions of a home detention curfew licence on release from prison. The Electronic Monitoring Use of Devices and Information Scotland Regulations 2025 limit the use to GPS to conditions imposed when Scottish ministers release an individual from custody on HDC licence. The regulations would also allow for a continuity of current monitoring arrangements, allowing existing radio frequency electronic monitoring devices to continue to monitor the court disposals as set out at Section 3 of the 2019 Act and the conditions imposed on an individual on the release and licence as set out in Section 7 of that Act. The regulations also clarify the maximum period for which information obtained through the use of radio frequency and GPS-enabled electronic monitoring devices would be retained, and the purposes for which the Scottish ministers or those acting on their behalf may share that information. And I invite committee to consider the Electronic Monitoring Use of Devices and Information Scotland Regulations 2025.
Super. Thank you very much, Cabinet Secretary. So I'm now going to open up to members for questions, and I'm going to bring in Katie Clark and then Sharon Dowie. Katie.
Thank you. And Cabinet Secretary, I warmly welcome that you're bringing these regulations today. As you know, myself and Paula McNeill have been calling for GPS monitoring to be introduced in Scotland for some time, and the legislation was actually passed in 2019. And it would be helpful just maybe to get an understanding as to why it's taken so long to get to this point. I appreciate this is a far from unique position, that there's often delays between legislation being passed and the policy being implemented, but it would be helpful to get a better understanding as a committee as to why there are such delays.
So actually, in respect of GPS, I wouldn't describe it as a delay, but I do very much welcome your and your support for GPS technology. I think it adds to the tools that we have, and it's a step forward in the right direction in terms of our ambitions to expand the use and widen the scope of electronic monitoring. Colleagues are probably aware that the new contract came into force in 2020. And thereafter, we wanted to ensure that as a priority that our plans for electronic monitoring aligned with the community justice strategy. So that's why there was, in the first instance, a big focus on electronic monitoring of bail. And also the use of electronic monitoring in community payback orders when they are applied at first instance. And now we are moving on to GPS to have the initial phase of that focused on home detention curfew. The reasons for that is so that the numbers can be quite small initially, and so that we can test the processes, because this is a shared tool between our justice agencies and our justice partners. So it's important that in terms of how they engage and operate with each other, that there's opportunity to learn from that before it is scaled up. But I do very much appreciate that actually across the political spectrum there is an interest in different forms of electronic monitoring.
Thank you. And clearly, given the the problems we've got with the overcrowding in the prisons, these kinds of tools are incredibly important. But GPS monitoring is already widely used in England and across Europe, and has been for many years. So there must be much to be learnt from that. So could you perhaps, Cabinet Secretary, give an indication of the timetable now? Because I think many of us are frustrated that this tool hasn't been in operation for many years. So it would be helpful to know how quickly we're going to actually see this monitoring in place. If you could maybe provide us an update on that today.
Okay, and I think it's a fair point to reflect that GPS and other forms of electronic monitoring are widely used elsewhere in these islands and across Europe. We have certainly learnt much from the pursuance of GPS in England. We are not tethering people to a wall for their devices to be charged for example. That would be one example of very valid learning on the basis that if we're not treating people like human beings, that their prospect of success diminishes, and I'm sure Ms Clark appreciates that. So what we want to do, because the numbers will be quite small, because home detention curfew is quite a bespoke intervention. Yesterday, in terms of the prison population, there were 138 people out in home detention curfew. Members will be aware of the steps that we've taken to increase the use of home detention curfew in more recent times. So we would anticipate that at any one time, probably up to about 20 people on GPS and home detention curfew. And we want to have an initial phase for around a year. And then, once we are absolutely sure that there are no issues with processes, those operational processes of engagement, that we will look to scale that up in terms of other orders as well, because that would be an important next stage. So much depends on what we learn. It's important that we use GPS in the first instance with one order, as opposed to initially rolling out across a range of orders, and that's about the complexity of operational processes amongst justice partners.
Thank you.
Thank you very much. Sharon Dowie.
Thank you. I think you've kind of covered some of it there actually in your answers to Katie Clark there. It was more about the financial impact of it. So at the moment it says that there's one-time costs which are going to be 210,000, and that IT change cost will fall on the Scottish Government. it then says that the G4S have it in their contract. And I know it does say that there's only going to be around 10 to 20 people that are going to be monitored initially, but I was just wondering to get more detailed. Is that money that G4S have already been given? My concern would be that that money's already been spent on other things, like to do the radio frequency monitoring that they already do, and that we then have people going in to get GPS monitoring, which we do welcome as well, so I'm glad to see it coming in. But my concern would be that if they've maybe already spent the money on other things, that they wouldn't be doing the monitoring that was required. And do they have the capacity to do it?
So we've always found our partners very keen to expand on electronic monitoring. So I don't have any concerns in that respect. Let me run through the costs. So in terms of the GPS service per annum, that will cost £210,000. There's a cost installation, and that's a one-off cost for both the fitting and the removal of a tag. That's £139.58. And there's also there's a daily cost for monitoring per monitored day, and that's slightly more expensive for GPS in comparison to radio frequency, but it's like £7.20 versus £5.99. From the government's perspective, we're increasing investment in electronic monitoring, and the budget's had a 10% uplift, so there is an additional £500,000 being put into the budget. But I'll ask Graham if there is any more to be said in and around the detail of the contract.
Yeah, the Cabinet Secretary covered it. There's bandings provided for both, so the 210k is an estimate based on that expected usage of what we think it will cost. It's not money that's already handed over. That is what will be handed over when we see the GPS numbers come forward.
Okay, right, thank you.
Okay, thank you very much. Any other members want to come in? No? Okay, thank you very much indeed. So our next item of business is to consider a motion to approve the affirmative SSI on which we have just taken oral evidence. So can I invite the Cabinet Secretary to move motion number 6SM number 15677 in her name and make any brief additional comments that she'd like to make.
Thank you, Convener. I move that committee approve the electronic monitoring use of devices and information Scotland Regulations 2025.
Thank you very much. Do members have any other points that they would like to make? No? Okay, thank you. So can I invite the Cabinet Secretary to wind up and press or withdraw the motion?
I'll press, Convener.
Thank you very much. So the question is that with regard to motion number 6SM 15677, that the Criminal Justice Committee recommends that the electronic monitoring use of devices and information Scotland Regulations of 2024 be approved. Are we all agreed? Great, thank you very much. So the next question is whether members wish to make any recommendations in relation to the negative instrument, that's the Electronic Monitoring Approved Devices Scotland Amendment Regulations of 2024, or SSI number 354 of 2024. Otherwise, are we content that this comes into force? Are we all content? Super, thank you very much. And finally, are members content to delegate responsibility to myself and the clerks to approve a short factual report to the Parliament on the affirmative instrument? Yes. Thank you very much. And this will be published shortly. So thank you for that. And I'll just briefly suspend the meeting for a couple of minutes to allow a changeover of officials. Thank you. Thank you. So our next item of business today is an oral evidence taking session on an affirmative instrument, and that's namely the Rehabilitation of Offenders Act of 1974, Exclusions and Exceptions, Scotland Amendment Order of 2025. So we're joined again by the Cabinet Secretary for Justice and Home Affairs, and I also welcome back to the meeting Graham Robertson, Head of the Public Protection Unit, and Louise Miller, Legal Directorate at the Scottish Government. And I refer members to paper number 3, and I intend to allow around about 15 minutes for this evidence session. So can I invite the Cabinet Secretary to make some opening remarks on the SSI? Cabinet Secretary.
Thank you, Convener. The purpose of this order is to enable Police Scotland to be able to lodge extract conviction information on spent convictions at the same time as making an application for sexual harm prevention orders and sexual risk orders. These new orders were introduced in March last year and replaced sexual offences prevention orders and risk of sexual harm orders. The Rehabilitation of Offenders Act 1974 provides that once an individual's conviction has become spent, they shall be treated for all purposes in law as a person who has not been convicted of or sentenced for that particular offence. There are exceptions to this rule, which include applications for sexual offences prevention orders and risk of sexual harm orders. This means that Police Scotland can request relevant extract spent conviction information from Scottish Courts and Tribunal Service in support of an application for these behavioural orders. At the time of the enactment of the Abusive Behaviour and Sexual Harm Scotland Act 2016, a consequential amendment could have been made to amend the 1974 Act or make provision under it to ensure that the new behavioural orders were treated in the same way as the previous sexual behaviour orders and could also be exempt from Section 4.1 of the 1974 Act. Following a period of operational running, it has become apparent that making this change would indeed be helpful to allow Police Scotland to lodge relevant extracts of spent convictions alongside applications for sexual harm prevention orders and sexual risk orders. Under general disclosure, any conviction which leads to a sentence of greater than 48 months is never spent and would always be able to be disclosed. As such, the higher tariff sexual offences will have been able to be used to inform applications for the new behavioural orders where relevant. What this new order does is allow for the consideration of lower tariff offences which have become spent in an application for a new behavioural order where appropriate. While these court extracts are not a prerequisite for lodging an application for a behavioural order, and we understand that the court may more often be concerned with the individual's recent behaviour than what they did years ago, this SSI will help ensure that court extracts of relevant convictions can be lodged at the same time as an application to provide potentially useful background about the individual. And this is a change to facilitate current operation process and one supported by Police Scotland. So this is just a brief overview of the draft order, Convener, and its context, and I'll be very happy to answer any questions.
Thank you very much, Cabinet Secretary. I suppose if I can just come in before I open up to members, and you probably set it out in the sort of final remarks that you made there, with regard to the sort of rationale for Police Scotland requesting this change. So I suppose when I was reading through the papers, it did occur to me that perhaps more recent information about an individual would be more relevant in the context of an application for an order. So is there anything more that you can say just with regard to the rationale for Police Scotland seeking more historical conviction information?
So, I mean, as I said in the statement, Convener, in terms of where there are relevant convictions of 48 months and beyond, they are never spent. The issue is around those low tariff offences and ensuring that there's the relevant provisions so that the extract information on those offences that are currently not accessible at the point of the application. And that's an important distinction, because courts can and do release extract information on convictions to the police, but that involves a dialogue, a process. So in terms of efficiency, what we actually want is for that information to be made at the time of the application. As I said, it's not a prerequisite to making an application, and very often courts will have that historical information because people are known to them, but it's very much about having the fullest possible information to be made at the time of the application, as opposed to having a process thereafter.
Yeah, thank you. That's helpful. Pauline McNeill, you'd like to come in.
Thank you. Good morning. Just trying to get my head around this. So, Cabinet Secretary, does that mean that prior to this SSI, the extra information for lower tariff applications weren't available?
So they weren't utilised at the time of the application, but the courts can and do share information on unspent convictions to Police Scotland, so so the flow of information can happen, but just not at the time of the application. So that would involve a process.
Because it's getting that information a bit earlier, then.
Yes, just
Right.
getting it, just so when all the information is presented to the court by the police, it's all there at once.
You said unspent convictions. Does it also include spent convictions then for lower tariff?
So the purpose of this order is to be clear that the Police Scotland can access what was spent convictions for those lower tariff.
Right, because they wouldn't normally be available because they're spent, and that's the purpose, right?
So
Understand.
there's an
Right.
exception.
Does that mean then, I'm trying to understand the purpose, so I understand what it does, so it makes it available slightly earlier and it gives more information in relation to the application for the order. In your view, does it make it more likely that the order would be granted then if we are still legislating for a change? So what is the purpose then? Why is it needed earlier? Does that mean that the police are making an application, they obviously think it's required?
Yeah.
Does having that information, I
So-
suppose, give the police a better chance to get that application granted?
It's not. It's more an issue of process.
Right.
So it'll be for the court to, put a value on, current behaviour, past behaviour. So it's, I couldn't possibly say that whether access to this information will increase prospects of success in terms of the police achieving these orders. But obviously, common sense, you want the fullest range of information to be presented, the fullest range of relevant information, and then the court will attach a value to that. So it's more an issue of process. We don't want a to and fro post-application between the courts and Police Scotland. And as I said, that it's a potential gap is how I would describe it. And since these new orders that replace preceding orders, that was March this year, and Police Scotland have raised it with us. So, and they raised it with us in August.
So
we're
it'll make
sought to
the
address
process smoother, but just for completeness. But is the change to this process including information that previously wasn't given in relation to lower tariff offences?
It's not as
No.
it's not. I
It's a
don't
bit more
think it's as direct as that, because the courts.
That's the confusing
could-
bit, because
yeah,
you're
yeah,
saying it's
the
process, and I
RCs.
see that, but
Yeah.
you specifically said it would include lower tariff offences
Yes.
where it used to apply to higher tariff offences. That does look like a substantial change.
It's
but-
not a substantial change. But what
Can I
Louise
just
suggested.
clarify? It's not purely a matter of process. The position where a conviction is spent is that evidence about it isn't generally admissible in future court proceedings. So that's the reason why Police Scotland have had difficulty getting extracts. It's because an exception isn't there for these new orders, so to allow evidence about those previous convictions to be admissible in these applications. There was an exception in place for the old orders,
Right.
and the legislation relating to those was
see.
repealed in March of 2023, and there isn't an exception currently for the new orders. We don't think this has actually derailed any applications. I think SCTS are aware that this is a technical issue that is in the process of being
right.
sorted, but we just need provision to allow evidence about those convictions to be admitted where it's relevant, and Police Scotland can then obtain extracts to show that those convictions have taken place.
Thank you. That makes sense. So it is a gap. I just wanted to be clear before we come to the conclusion on it, because, yeah, I think you've also got to be careful about spent convictions. They're there for a reason. So I just wanted to be sure that what we're doing is proportionate, and I'm satisfied about that. Thank you very much.
Thank you. Liam Kerr.
Thank you, Convener. Good morning, Cabinet Secretary. A similar question occurs to me. Because you said it was a potential gap, but earlier in your remarks you said it has become apparent that this change is needed, and that rather implies that there have been some cases where the police have been perhaps slightly hamstrung or perhaps less able to put together an application. Is that correct then? And if so, are you aware of any negative consequences to this change not having been in place already, such that it is now needed?
So it was a matter that was brought to my officials' attention in August, and we want to seek to rectify it. I did describe it as a potential gap, but it is a matter of fact to see that the new orders, didn't have the same. This wasn't an issue in the previous orders. If I can put it that way. So in terms of the assurances that I've sought from officials and the information my officials have had from the courts and for Police Scotland, as far as I can be assured, there's not been any negative impact. And that goes back to the fact that courts tend to be more interested in current behaviour. I mean, I appreciate that's a generalisation, and that they can and do share information with police on previous convictions and extract information, and that relates to the fact that, well, court is in public, so that information is available. So, hence, you want that information to be included as part of the original application. I suppose hence my commentary around the process of it, although as Louise has emphasised, this is not just a two-dimensional issue of process. So it is one of completeness, because we want these orders to work on a par with previous orders. But there's been, to the best of our knowledge, no negative impact, and any impact has been minimal, because it's required a bit more work between police and the Scottish Courts and Tribunal system.
I understand. Thank you.
Okay, thank you very much. Do any other members want to come in? No? Okay, thank you very much for that. So our next item of business is to consider a motion to approve the affirmative SSI on which we've just taken oral evidence. So can I invite the Cabinet Secretary to move motion number 6SM number 15515 in her name and make any brief additional comments that she wishes to make.
Thank you, Convener, and I move the motion that the Draft Rehabilitation of Offenders Act 1974 Exclusions and Exceptions Scotland Amendment Order 2025 be approved.
Thank you very much. Do members want to come in with any final points? No? Okay, thank you. So can I invite the Cabinet Secretary to wind up and press or withdraw the motion?
Press.
Thank you. So the question is that with regard to motion number 6SM 15515, that the Criminal Justice Committee recommends that the Rehabilitation of Offenders Act of 1974, Exclusions and Exceptions Scotland Amendment Order of 2025 be approved. Are we all agreed? Thank you very much. So, thank you. So, finally, are members content to delegate responsibility to myself and the clerks to approve a short factual report to the Parliament on the affirmative instrument? Thank you very much. So, this will be published shortly. So, thank you. So, that completes our consideration in public this morning. Thank you to the Cabinet Secretary and your officials, and wish you all a very happy Christmas and good New Year. And we will meet again on Wednesday, the 8th of January, where we will be looking at the challenges facing Police Scotland when called to an incident involving vulnerable members of the community. So on that, I'll move into private session. Thank you. Thanks very much. Thank you.